Hello and welcome to Bar and Bench interview series. Today we have with us just B.A. Khan. He was enrolled as an advocate in Delhi Bar Council in 1971 before shifting back to Srinagar in 1972. In the same year, he was appointed as a lecturer in Kashmir University and served there until 1978. In 1986, he was appointed as an additional advocate general and he served in that capacity till 1990. In 1990, he was appointed as permanent judge of Jammu Kashmir High Court. Over the legal career, he also got to serve as the acting Chief Justice of Delhi High Court and judge of Madhya Pradesh High Court. He ultimately retired in 2007 as the Chief Justice of Jammu Kashmir High Court. And in 2014, he was appointed as the chairman of State Accountability Commission in Jammu Kashmir. Sir, we are pleasure to have you today.
Thank you.
The first question that comes to my mind is that you have served in India's higher judiciary at a time when the judiciary underwent significant legal as well as political transformation. How you reflect on your journey, your journey in judiciary?
Now, for me, the journey has been both exciting and smooth, and it has been a learning experience all the way.
Mm-hmm.
So I have seen ups and downs. I have seen the inside of judiciary, and I have held opinions on issues which are facing judiciary all the time when I was on the bench or out of bench. So, all told, my journey has been a happy journey, so to say, in the judiciary, which has been my bread and butter for all my life, and which I have, in my own humble way, tried to uphold the values and contribute something to the cause of justice, apart from technicalities and all that. And that has been my journey.
Oh. So, since you have served as the Chief Justice of Jammu Kashmir High Court, I would like to ask you a few questions on the side court. Justice Geeta Mittal, who also happens to be former Chief Justice of Jammu Kashmir High Court, she expressed concern in 2014 over the lack of even basic infrastructure in Jammu Kashmir High Court. As per my knowledge, the current budget doesn't allocate any funds for the construction of new court complex, high court complex, so to say. And the centrally sponsored schemes that pertain to the judicial infrastructure, they exclude the high courts. In your view, does the lack of adequate infrastructure affect and impact the justice delivery system? What's your take on it?
See, our lack of infrastructure is not an issue limited to Jammu and Kashmir. It's an issue which is there confronting the institution at the national level. So all the time when somebody talks about delay in justice, tariq pe tariq, this, and the stock answer to that is, we don't have infrastructure, we don't have this. So infrastructure in Jammu and Kashmir is not a major problem. Madam Geeta Mittal, which you mentioned, she was recommended by me, incidentally, to be the judge in Delhi High Court. So she must have talked about the state, coming to the state first time. But in states, it all depends on whether your Chief Justice of the state is dynamic. If he is, then he can get the requisite things done. But mostly you see that the Chief Justice come from outside and they go on lazing their time here, and so they don't focus on the requirements of infrastructure, nor do they care to assert to get requisite funds, because funds are to be given by the government. Now, unless you assert and in a way constrain the government to give you whatever. For example, I tell you, the infrastructure which I created in my time was not done for about 20, 30 years. I remember a block of the High Court which I ultimately discovered was pending for 20 years. That was because of inaction, sorry. So it is not a problem where you assert where the is to be works are got to be done. That's not a problem.
Okay.
So, but overall, if you see, if you talk in terms of budget, for budget, our judiciary has a minimal budget all over. It's in the national budget also, it's in the state budget also. And the reason is that, in my view, and I have always said it, that it is being treated as a no priority judiciary, as a no priority as against the government, which is the executive branch, and executive branch is holding the purse, and we have been all the time demanding that if you have to make judiciary actually independent, then it must be enjoying its own financial jurisdiction and financial domain. That's not happening, that nobody is prepared to use. So, talking about Jammu and Kashmir lack of infrastructure as against other states, we are happily placed in Jammu and Kashmir. The only thing is, if somebody has the initiative to get things done, that is the problem.
If we see post COVID-19 pandemic, the Indian judiciary has increasingly adopted technology, with e-filing and virtual proceedings becoming common. Do you think that the increase in the adoption of technology in Indian judiciary will address the issue of accessibility?
Well, I have my own doubts, but those are different factors. When I say that technology will help only when you have a basis created for use of that technology. Because I remember one time when free laptops were distributed. That time Chief Justice of India was Justice Lahoti, and he called that year to be the year of computerization. And free laptops were distributed to the judicial officers. So those became what? Those became toys for their children. Why? Because the whole generation was not given to that, to use of that. Same happened to us. We were given training in Delhi High Court in computerization. None of the judges took it seriously, and none of, except Justice Madan Lokur, nobody knew what to do with it. So, if you use technology, it will definitely, because your physical waste of time, your physical appearances, and all those things will stop, and it will facilitate the quick disposal of. If your whole basis is trained, for example, it will expedite matters, it will help. Technology definitely will transform the face of judiciary, provided it is used properly and used with some kind of a focus. But if it is used as a part-time thing that, a judge has a computer in his chamber but he doesn't use it. In that time in Delhi High Court, we had chamber computers in everybody's judge, but nobody would use it. So it is not that kind of a thing. But wherever they have used it, later I saw in Delhi, for example, in Tesazari and Patiala High Court, computerization was done and looked after, supervised, accelerated, and it gave good results.
As you rightly pointed out, the flip side of the online proceedings has been the recurring instances of inappropriate behavior during the virtual proceedings. To quote two most recent examples from Gujarat High Court, we saw in one case a person attended the court proceedings from the bathroom, and in another case, a senior advocate was seen sipping beer during the online proceedings. How this has almost become a menace.
Those are aberrations. It doesn't happen generally.
It happens, but quite often.
No, but these are some hot-headed people you will find even otherwise without this virtual thing. You will find in the bars, somewhere in the courts also, people behaving like that. So that is not a major problem anyway. But during COVID, it did help. The virtual mode did help. And it should have been carried forward. But there are certain proceedings where you can't do things virtually. For example, you have to seek clarification from a lawyer, or the whole dialogue goes on and so on and so forth. Now you have to, your thinking processes go on changing on lawyers' conduct and all that stuff. So in some cases it may not be that helpful also, and virtual hearing may not be a panacea for all our this thing. So physical hearing is required, and physical requirement is also required because you have to establish a rapport with you are seeking justice. Problem today our system is they are treating it as some kind of a bureaucratic disposal. Now for seeking justice you have to establish a rapport with the bench and see how it is going on and how it's moving on and so on and so on. So technology plus human resource is the way forward.
Okay. Now let's come back to Jammu Kashmir. Recently, the newly formed National Conference Congress government approved the establishment of National Law University after protracted struggle, I would say, because it was approved way back in 2018, but for some reason or the other reason, we were not able to have National Law University. In your view, were the existing legal institutions able to provide the quality education to the people of Jammu Kashmir? And to add to that, how do you see the establishment of National Law University is going to change the legal education landscape in Jammu Kashmir?
No, legal education has not been satisfactory. It's not only in Jammu and Kashmir. It is, if I give a history, I was a part of this revival of legal education at the national level. And Bangalore Law University was the first which was established that time. And Justice Ahmedi, who was the Chief Justice of India, he was leading the campaign for legal education, because legal education had come down to a level where if a student would not get anything anywhere, he would ultimately seek an admission in some law college, private or wherever, and come out with a certificate and then go to the court and making no sense of it, giving no assistance or discharging no lawyer duty there. So this problem was thought to be resolved through establishment of a 5-year course, a professional course, just as you have in MBBS or engineering or something. That is how this 5-year course started, and first it was established in Bangalore, which is Bangalore. Then we had a number of colleges. I had also contributed to establishment of in Bhopal, 5-year course. Then it was also perhaps in Pune. Then it was in Rajasthan. What is that place called? It was established there also. And we have so many, I think you have 9 or 10 colleges where a 5-year course is going on. That helps because the legal education contours have changed in the light of the new trends and new technology and new concepts and new branches of law coming in. That time we never knew anything about intellectual property. And today also you will have most of the courts in the state do not know anything about it. But this branch is now growing. If you find in Delhi, Bombay, major litigation is in this branch. Therefore, all these branches have diversified. And though that type of a teaching has also diversified, and the faculty of these colleges, a special care is taken in those 5-year colleges where professional courses are going on to recruit a competent faculty on merit, which is not the case here or elsewhere or elsewhere. The result is if your faculty is not good enough or competent enough, your product is not going to be a good enough content. I am not talking of private colleges here because those are only fulfilling a formality. So that way, you can't expect that from a private college in Jammu and Kashmir, a student will come out to be a very good product, or he can prove to be a very good lawyer. Or that is one aspect of it. Second is that the education given in such institutions is unrelated to the field of litigation in the courts.
Practicalities.
So it has no connection. For example, what they teach you in a private college here, if you go to the court and if somebody asks you, please draft this application for me, you will not be able to draft because you have not been told how to do it. So that education and the court litigation has no connection, so to say. But in professional colleges, you have now internships from the very first year. Students are attached to the legal institutions where they gain practical experience while carrying on their education, and so that they are equipped when they land in a court premises. They are equipped what to do, how to do, where to do. Not 100%, at least 20%, 30% they know. But these are totally blank, the other side of it, which come from nowhere. So that is the difference.
So,
And the university you talked of, that was initiated my time also. We initiated it in Delhi. Now Delhi National Law University is
is one of the
one of the best going. That was initiated by us that time. And when I came here, that format I wanted to introduce here. But after my exit, that no initiative was taken on that. And later on, I think it has fructified in some manner. And I don't know at what stage it is today, but as and when it's established, it will be an asset and it will be an institution which will help the local talent and which will fine tune it and make it. Today if you find most of our law graduates, girls, boys, they are shifting to Delhi, working in various law firms here and there, so on and so forth. That is because of the lack of work here. We don't have any commercial activity here. But with this, their competence level will rise. And even if they go wherever, whether they go to Bombay, Delhi, wherever, they'll be going with their head high. But presently it's not so.
okay. One of the challenges that remains in national law universities is the exorbitant education.
Exorbitant education means what?
It's high cost education. The average fee in these NLUs is so much that a person from ordinary family cannot afford it. So, what do you think can be the way forward to tackle this issue? Because many of the students who otherwise could qualify CLAT and get admission in these top national law universities, but they aren't able to because the cost of education is so high that it becomes unaffordable for them to pursue education in these national law universities.
No, I don't know there's a way out because see, law, legal, education, nobody is going to subsidize it. Then you will have to do it in MBBS also, you will have to do it in engineering also. And if you are going to be getting into a prestigious institution, then you have to pay for that anyway, beg, borrow and steal. And today educational loans are also available. But there are reservations also in these kinds of institutions where poor, backward students have to pay nominal fees, hostel fees, and faculty fees. So, but trying to say that it has become expensive, and that part will remain expensive. Because, if, for example, if you go to Harvard, you are not going to say that no, I must be charged less there. It can't be that. If you are seeking excellence, you are going to a prestigious institution, then you have to pay for that, whether you borrow a loan or whether you borrow this thing. I don't think any institution is going to make it free. More so a legal education. It means that legal education is treated to be something superfluous.
But ideally, wouldn't it be upfront with the basic tenets of our constitution that espouse for equal opportunities?
No, equal opportunity concept you can't apply into this. You want to buy a brand something, then you pay for the brand. Though the ordinary wear may be the same. So there is no question of equality in this. What is it? That's an equality of treatment between two equals. That is the concept of equality. Not this that a poor and a rich and they go to an institution and they must be treated.
So the problem is larger because many of the employers you would see there has been instances where the employers exclusively say that we will hire students from the national law universities.
Is because of their educational excellence, because of their training. Because most of these companies they need a requirement. They have a requirement of their own. So to meet that requirement, they want to pick up the meritorious.
So you think it is justified to exclusively debar students who come from?
No, nobody is debarring. Who is debarring?
There has been instances.
No, who is debarring? See, nobody is debarring. What you are wanting is that I am a brilliant student, therefore I must not be charged anything. Then go and seek a scholarship. Go and seek an educational loan, which is freely available. But you can't say make it free for me because I am in my own right something meritorious or brilliant. So it's not a case of inequality.
So now let's come to a topic that continues to be a topic of say hot debate, collegium system. Do you think the current system of appointing judges needs to be reformed, or you think that irrespective of all its flaws, it continues to be the most viable model of appointing judges in a way that helps us to maintain that independence of judiciary? What are your views on it?
Umar, I've been tired of debating this issue for the last so many years after this collegium system started malfunctioning. If you have some little idea of any little background of this, you know how it started. The power to appoint judges lies with the president under the constitution and has to be done in consultation with the Chief Justice. And there was a time when judiciary was being fired from all sides. There was a hire and fire and after emergency and all that. And judges were being picked up, transferred, so on and so forth. Now, then it was thought that there was a lot of interference in the judicial functioning. So the case was that Gupta case, then we had Advocate on Records case, in which this provision of consultation with Chief Justice was what do I say, was interpreted in such a way that it was held to be a consultation which is mandatory. Chief Justice's opinion is mandatory on the President. And then Chief Justice, it was expanded and said that no, Chief Justice not alone, then 2 people more, then 5 people more. That is called Advocates on Record, second case and all that. Now the expectation was that previously the appointment was being made by the executive, and executive was appointing only those people who were their own favor of their own this thing. And now that judges, because judges credibility is attributed to judges, impartiality is attributed to judges, expectation is that the judges will do it on fairly and honestly and so on and so forth. So it was thought that this power should be taken over by the judiciary, which was done by this interpretation, which interpretation was out of the blue. And but after some time, it was discovered that these judges are also no good. They are doing the same thing which the executive was doing. Now, collegium functioning was attacked from left and right. It's being still attacked on favoritism, on nepotism, on lack of transparency, on no criteria basis. You choose, if I am in the collegium, I say this Umar is my man, he has to be taken. Then the second member will say, okay, Zafar is my man, he has to be taken then also. Then it was a wheeling and dealing affair it had become, and it was partly it is going on like that. So there was an outcry, and out of that outcry there was a debate for having a national appointment judicial commission. So for that we debated, and we also in a way pleaded that that is the way out and all that. Now after the things worsened, there was a political consensus, and they enacted that National Judicial Appointments Commission, GAC. And in that, what did they do? The way it should have been done, as we were that time pleading, that it should be done on the model of South America or England, it should be broad-based, and all types of interest should be, stakeholders should be represented in this, and then there should be a criteria, just as you have a criteria for every appointment, that on that criteria, people should be selected on merit, so on and so that there is no scope for outside interference by executive or wherever. That didn't happen. The composition of that commission was such, it was again a government dominated. They said 3 people from us and 2 people from the judges, Supreme Court. It was challenged in the Supreme Court. Supreme Court also delivered a judgment, where we criticized that judgment also. And that was too much, saying that the law minister's presence will undermine and interfere with the independence of the judiciary. Now, it is law minister who is otherwise the key. Even if you have a collegium, all files go through him, he stops those files, he scrutinizes those files. So, is he not interfering just now? Now, if he was a member of that board, what kind of an interference you would have made? But that apart, the composition of that commission had suggested in that legislation was not a satisfactory composition, which we had expected and which we thought would be. Then there was a tussle on that criteria, which we call that memorandum of, what is that called, memorandum? So that's still not being resolved. No, in that government says that we must have the final say to reject a candidate on the basis of this. And so far, the Supreme Court Chief Justice have resisted that. Now that is still pending. But inside of it is altogether a different ball game. No, it's not as we are saying it publicly, oh, independent, so independent. Government always has a hand in the appointment of judges, right from the word go. And the procedure is that, for example, in case of High Court judge, the recruitment is initiated by the Chief Justice of the High Court and his collegium. That proposal goes to the Chief Minister. and then it goes to the governor. If both chief minister and governor are not satisfied with it, they hold it and they put their own choices. And if you have a surfera chief justice, then grind to X, X to grind. No, it stopped there, or if it is cleared there, depends. Then it goes to the Supreme Court Collegium, they have their own problems there. Then it goes back to same route, law ministry, and then to PMO, and then to the president. This is the route. And in this route, who says that government has no say? It is government all through. But the only difference is that they don't directly pick up a candidate now as they used to do previously. Now, if you ask me whether present system is good or bad, I say it is good comparatively to an executive appointing body, not a judicial commission. Judicial commission, if there is one proper judicial commission, which is constituted and which is broad-based and which represents all stakeholders and which is comprising of men of integrity, as you take care, for example, in case of a Union Public Service Commission and so on, then yes, that judicial commission, appointments commission, he will have its own secretariat, it will have its own procedure, it will have its own criteria, it will have its own merit assessment mechanism, and then you can expect a meritorious candidate will become the judge, who will not be prone to the influences, external influences, and so on and so forth. But if you ask me between a government appointment and a present collegium appointment, I would prefer present collegium appointment because it's a lesser evil. It's a lesser evil. The only thing is if they set their house in order, if they have a criteria and a criteria made public, if they have transparency, and if they have this whole thing in the public domain. Now see what is their selection process. I was reading yesterday that Chief Justice of India saying that we interviewed 40 candidates and selected 25 or whatever. What is that? 40 candidates you interviewed and then onward basis you selected those 25. Was it on looking at them or what? Looking at what? Where do you have time to look at their backgrounds, their antecedents, their performance, their judgments? And who does it? Nobody. Now, even if you have interviewed, I called Umar tomorrow, he's a candidate. No, I like him. Okay, you are selected. Is that the selection? No, it's not going to be this way. Just as we have in UK, there is a procedure. The candidates have to apply, the candidates have to appear in an interview, the candidates are tested on different accounts, like integrity, like this, like that, like their... and mostly, for example, if you have to test a candidate's judicial approach, which we are lacking today. You know what is the biggest problem in judiciary today? Biggest problem is lack of judicial approach, lack of judicial attitude, lack of judicial compassion. These have to be in the candidate. If you have a candidate like a bureaucrat who gives tariq pe tariq, then what are you selecting? You are selecting same thing. So which does not. And what are you calling? See, the problem is, what are you calling that he is a performing judge? He is a good judge. What is he performing? Now, if I dismiss 10 revision petitions in a day, I am a good judge. I am a very fast-moving judge, and so on and so forth. But nobody knows whether he is doing justice by doing that or not. Whether he is getting hold of the aggrieved person's issue or not. That is non-existent. So, answer to your question is that in the present circumstances, collegium is a lesser evil, but it can be a satisfactory mechanism if it evolves a procedure, a methodology, a criteria, and makes selection and makes it transparent and puts it in the public domain, and as against a government selection which will be on the government's own considerations of whether he subscribes to that thinking, whether he is a man of their choice, so on and so forth. So this is a better thing as on today. But if you have to replace it, then you have to do it by a proper appointment of a Judicial Appointments Commission. And that commission has to comprise of people of proven integrity representing all stakeholders. And that commission has to have its own secretariat, that commission has to have its own procedure, that commission has to have its own mechanism of selection. And that selection has to be made binding then for appointment on the government, on the president.
I would like to draw your attention to a related question that was in the news for some time now. Justice Yashwant Verma, the judge of Delhi High Court, a pile of unaccounted cases, recovered from his house when a fire outbreaks in his house. After that, in-house committee indicted him. While he contended that he was not given opportunity of being heard. Do you think that the instances of corruption that has propped up over past few months, it typifies towards the larger problem that the judges that are being elected, appointed, it doesn't undergo no proper security because of that the judges that are being appointed, they turn out to be corrupt.
No, see, this corruption is something which necessarily nobody can detect at the time of appointment.
Mm.
We take care of going through his records. There are agencies like IB and others who go and investigate, but their investigation is also faulty. They have it conducted through police walas, ordinary police walas. But what I am saying is that it is not possible to detect whether the candidate is corrupt at the time of appointment, 100%. Though you can know, for example, as a lawyer, what has been his conduct, as a subordinate judicial officer, what has been his record and all that stuff. But the corruption is something which is existing. I have said it in many debates and reviews. It will be unrealistic to say that no, we are dudh ke dhulle and all that stuff. No, nobody is a dudh ka dhulla even in judiciary. Somebody, Justice Baroka, said one day that what was his name? That it is 20%. Some say it is 50%. Some say whatever. But fact of the matter is that corruption exists in judiciary in varying degrees. Now, if you sit in the bar room of Supreme Court, which I have done, you hear so many stories. So many stories. Mostly, if you grant a bail in a drug case, can you imagine what is the volume of money involved? Similarly, in these big cities like Delhi and all that, if one chooses to be corrupt, he can be a billionaire or a millionaire within a very short time. Now, I don't know how this truckload of cash came into this judge's house and how it was set on fire and how it has vanished suddenly and why no FIR was that time, why police did not act. These are all mysterious things, I don't know, and ultimately they are justified in the name of independence of judiciary. Oh, if we had done this, then it would have harmed the independence of judiciary. That's a bakwas. But in Justice Verma's case, I was satisfied that Chief Justice that time, Justice Khanna, he acted according to the rule book. See, we have no accountability law existing at this time. The only law we have is the Judicial Inquiries Act of 1968. 68. Now that comes into play if a judge is under impeachment and so on and so on. Now Justice Verma's case should go to that inquiry under that act. Now if they are dispensing that inquiry, that is going to be a flaw, a legal infirmity which Justice Verma can challenge tomorrow. Because this gives him an opportunity of being heard. That 3-judge inquiry did not give him the opportunity which should be, for example, cross-examination. Somebody has to prove it, I saw this cash. Somebody has to say this cash was burnt before me and so on and so forth. That didn't happen in that. So that can happen in this case, in Judicial Judges Inquiry Act, under Judge Inquiry Regime. Now, whether Justice Verma's case was dealt with properly or not, yes, it was dealt with, because we had no mechanism for taking action against him in such an incident. The only mechanism is provided in a Supreme Court judgment of 2019. Those 7, that's called 7 stages. 7 stages of taking action against an erring judge. And Chief Justice Khanna followed all those 7 stages. And this 3-judge inquiry was also a stage under that. And 3-judge inquiry report was meant to prima facie satisfy that yes, there was something wrong found there. And that is why after that, the next stage is you ask the judge to resign. I had first day pleaded that if he wants to save the whole exercise, he must resign on the day this burning cash was found. But he didn't do it. Now, he was told after 3-judge inquiry report that please resign. He said, no, I will not resign. Then the only option before the Chief Justice of India was to refer it for impeachment to the President and Prime Minister, which is going on now. Now, they are trying to build up a consensus on impeachment getting through in the Parliament.
Reportedly, he has been asked either to resign yourself or...
no, every well-wisher will tell him to resign, because some other people who were under impeachment, they resigned before the impeachment process went through the Parliament vote. Now here also people are suggesting, telling him you resign. But one mistake they are committing, because that law minister or somebody made a statement that since 3-judge inquiry report was there, so there was no need of holding an inquiry under the Judges Inquiry Act. In my view, that will leave behind a flaw, a defect, which Justice Verma can exploit tomorrow and challenge his impeachment on that. So best thing would be to go through that exercise also
and
have it speedily done and then put it to the Parliament for vote. And if you have a consensus in the Parliament, he goes. So he has been dealt with according to the procedure established as on present, which is prevalent procedure.
Given the evolving socio-political circumstances, what are the qualities that a judge must embody to uphold the independence of judicial review?
Judge must be an angel, as people expect him to be. I've been repeatedly saying that judge is a human being. He comes from the same place, same society. You are a lawyer today, tomorrow you'll be a judge. So what do I expect from you? That you should be angelish? Can't be. Now, broadly, the qualification, which out of experience I must tell you a judge must have. First is that his honesty and integrity. His honesty and integrity is number one. Then his so-called law of knowledge, which he never finds an opportunity to act upon. He must be fair and impartial. You can't be a judge subscribing to an ideology like that Allahabad judge.
Shikhar Kumar Yadav, Justice Shikhar
and
Kumar.
condemning a community or attacking a community.
Mhm.
How can that happen? When you subscribe to the oath of a judge, you owe your allegiance to the constitution.
Mhm.
You cease to be a Muslim or Hindu or Hindis or that.
Mhm.
Then how do you do that? You can't be. So if you are wedded to some kind of an ideology, every person who up to the point of appointment may have whatever ideology,
Mhm.
whatever his thinking may be. But the moment he takes an oath, he has to shed all his past legacy, what is called that, liability or legacy or whatever.
Mhm.
So he must be impartial, he must be honest, he must be fair,
Fearless.
and he must be fearless also. Fear means that you must be fair to what is
Fear.
before. Yeah, what is before you.
Mhm.
You can't have an adulterated thinking processes on this.
Mhm.
You have to be fair, whether he is this, whether he is that, whether it is this. Then he has to be fearless also.
Mhm.
Because in oath you say without fear and favor, I will do this and I will do that.
Mhm.
Without fear means what? You are not amenable to extraneous influences. You are not subject to any pressures. You can't allow yourself to be subject to any pressure and so and so. Favor. Oh, this is my case of my so and so, my friend, this. Therefore, I must get it through whatever the nature, whatever the merit. That's favor.
Mhm.
Or if I am acting in an administrative capacity,
Mhm.
I am favoring somebody. Nepotism, just as this collegium is accused of.
Mhm.
So these are, and law of knowledge of law also, of some knowledge. I don't say, because a judge takes a long of time, by then he retires to express his law of knowledge. You are not facing constitutional issues every day. Your constitutional issues litigation is hardly 15%.
Mhm.
And that arises where you may need some knowledge or you can acquire that knowledge also.
Mhm.
But you must have some basic knowledge of law on the basis of which. But that knowledge is not to to override your judicial approach, your judicial thinking, your judicial attitudes. No. Your apathy, your judicial compassion. In our setup, no judge takes any care of what this aggrieved litigant is going through or what is his problem.
Mhm.
Show me any judge, barring some exceptions, who directly establish a contact with an aggrieved party and tell him, what is your problem, please? Nobody. What they do, they will go and see what the lawyer is like.
Mhm.
If it's a high-fi lawyer, then they'll start hearing him.
Mhm.
That lawyer will be arguing some technicalities, some commas, some full stops, some this and some that, some that. Issue remains the same.
Mhm.
No, you don't go to the issue at all. Issue maybe I have done a case in Madhya Pradesh High Court where a limitation issue, whether a recovery of 3,000 rupees was within limitation of 3 years or not,
Mhm.
going on for 60 years.
Oh.
And nobody was going into that it was a recovery case of rupees 3,000. 3 generations had gone by.
Mhm.
That's by and large the problem facing the judiciary today. And any selection and any recruitment has to first take care of that their selection must ensure that these qualities are there in a particular candidate.
Mhm.
That's a must approach.
As you rightly pointed out, uh, judicial pendency continues to be one of the most pressing challenges that Indian judiciary faces, and it has been going on for so long. Cases are pending for years altogether, both in the higher judiciary and the subordinate judiciary. What, in your view, is the way forward? Because it has become an unsurmountable issue altogether now. What, in your view, is the way forward?
Now, this has a number of contributory factors which will not be able to and take care of in this discussion at the moment. But mostly, I say, as and when this question is asked from me, I say everybody is a contributory to this.
Mm-hmm.
A lawyer seeks adjournments only for his vested interest.
Mm-hmm.
A litigant sometimes also wants a lawyer to seek adjournments for his own. If you are a tenant, you would say, lawyer, I'll pay you 100 rupees more, get me a longer date.
Mm-hmm.
A judge is a lazy judge. He says, Tariq pe Tariq. He wants to be lazing in his chair.
Mm-hmm.
He also. So, this functional connivance
Mm-hmm.
is the most contributory factor to the delay, arising out of a bad approach, bad judicial approach.
Mm-hmm.
For example, if a judge is assertive judge, if he is not a lazy judge, and if he tries to go into the issue, it may turn out to be a recovery of 3,000 rupees. He doesn't go to that at all. On that, lawyer asks for a date, litigant also asks for a date, judge says, or jane do. Is the basic. That's why I say there has to be an attitudinal change in your recruitments, and you have to ensure that the people you are recruiting are having the recruitment. Judicial functioning is not a bureaucratic functioning. And our 90% judges are bureaucratic. They move the file from here to there. Just as in secretariat, you will find file moving here and there. And if you pay somebody something, then your file will go from one table to the other table. Judges are not bureaucrats. They have to do justice, they have to do grievance redressal. They have to go into the grievance. They have to see his plight. Why is a poor man knocking at my door? He must have some problem. And why don't you look at that problem? You are getting your salary only for that. You are not getting for listening to a Queen's English from a big lawyer. That doesn't happen. So that is one problem. Now then, attendant problems are just as you say, for example, people will tell you lack of infrastructure. Yes, lack of infrastructure is there. I have seen my subordinate courts. Subordinate courts means these civil judges. They are themselves writing those judgments, which takes them 5 hours, which 5 hours they could have disposed of 5 cases otherwise, because they don't have a stenographer. They don't have a place to sit. You'll see in most of the states, you have some 50% subordinate courts working in tenanted premises. In my time, I had 40% here in Jammu and Kashmir. In somebody's house, some court was running. Now it was that munsif sitting or whatever. In Madhya Pradesh, I saw a civil judge sitting on a box, that cotton box, because he had no chair. No, therefore you will say, yes, lack of infrastructure here. Then you will go to lack of infrastructure. There is official indifference towards judiciary. No, lack of funds. Then judiciary's proposals are not seen through in the secretariat. These bureaucrats have some inherent indifference to the judges' functioning and so on and so forth. That can be a separate subject. Similarly, shortage of judges. People will always tell you, see, look here, this is the ratio. We have one judge for so many people. And in America, this is so many people. So judges shortage is also there. But I say, even if you increase judges population, it's not going to get rid of the problem, because unless you change their attitudes, what problem will get solved? I had suggested that you have some few thousand retired judges just now, and last time there was a proposal that they should be appointed as ad hoc judges. Do it. You can have most of the things cleared by them. Engage them for 1 or 2 years. So but this is a very problematic subject, and this will require a time to tell you all the factors that contribute to the delay. But 3 major things are like this, which I told you.
Okay, thank you for taking your time and joining us for the interview.
Thank you very much.
Thank you so much.